I'm sorry, this is supposed to be recorded, so I need to start over again. Welcome to the Wills versus Trust webinar today. And if this is your first time attending, we're very happy that you've taken the time to join us. And if this is your second time, thank you for coming again. My name is Bernice Williams, and I'm with B. Williams Mobile Notary. I have partnered with Legacy One to share these monthly webinars with you, as we feel that this information that's being shared will be both important and informative to each and every one of you. Now, there's a couple of things I'm going to go over with you, and then I'm going to turn it over to our presenter, attorney Sedric Collins. From a housekeeping standpoint, we've muted everyone, or asked that you mute yourself so that there is no background noise as Mr. Collins is speaking. And then if there's any questions, there's a chat. You can type your questions in on the chat section, or there will be time for you to ask questions directly. Also, there is going to be a poll near the end of the session that we ask that you also share your comments on. So that's it for my housekeeping. Now, let's talk about attorney Sedric Collins. He is the founder and principal of Legacy One Law Firm. He represents individuals, families, and businesses in estate planning, entertainment, and intellectual property law matters. As a trusted advisor, Sedric prides himself in providing the unwavering level of service, which is client-focused and results-driven. He firmly believes that building authentic relationships is essential to creating a favorable outcome for clients, and has instilled this value into the fabric and culture of Legacy One Law. In his estate planning practice, Sedric provides high-value solutions for families and individuals, wealth preservation, asset protection, and protection planning for those we cherish most, our children. His engagement with clients differ from that which is found in traditional law firms because of his willingness to empower through education, as opposed to the mere drafting of documents, which may result in failed plan at death or incapacity. Sedric is the proud father of his 6-year-old son, Logan, and credits him as the source of his inspiration for designing estate plans for families throughout California. And he also attributes his love for performing arts to his parents, who are both musically gifted. I present to some and introduce to others, attorney Sedric E. Collins.
Thank you so much for that kind introduction, Bernice. And thank you so much for those of us who've joined us, whether this is your first or second time. Welcome. My hope to you is that you'll learn something and be inspired to take action to do something that's going to have a lasting impact on those who you care about most. And so what I'm going to do is I'm going to go ahead and share my screen, and we're going to jump right into tonight's presentation in just one moment here. All right. So welcome to, as Bernice said, I'm the founding attorney here at Legacy One Law Firm, and I'm the founder of a relationship-based firm that cares about what happens to our clients when something happens to them, whether it's through death or whether it's through incapacity. We want to be the trusted resource for our clients who may be going through very difficult and challenging times. And so we know we titled this kind of lightly wills versus trust, but it's really so much deeper than a will versus a trust. It's actually about legacy wealth preservation planning. So planning for a lifetime of protection, of guidance, and of love. So what I wanted to really start off by focusing on here tonight is kind of an opening thought. What is your why? Why did you join us here tonight? And we're going to start off by looking at some of the whys, why so many of us take this important planning process, this planning step. So why did you take your time out on a Thursday evening to join this webinar. For some of us, it may be about family. Those that we love the most, those we spent a lifetime building memories with, building a legacy for, whether it's a spouse or significant other, our children, or even our grandchildren. For others, it's about comfort, making sure those who we love are properly and adequately taken care of in the event of our death or our incapacity. And for others, it may be more strategic. You know, perhaps we want to plan for college for a grandchild. We want to make sure that a surviving spouse has enough resources to carry on, and we want to make sure that's protected. For many others, it may be all three. For some of us, it might be taxes. Have we ever heard of death taxes? Well, if you haven't, death taxes, they do exist, and we're going to touch on that here tonight. We're going to touch on maybe a couple of strategies that can maybe help mitigate or minimize taxes, because estate planning does also have an impact on tax planning. So we'll discuss that. For others, it's peace of mind. You know, we've worked so hard to develop and build these assets. Some of us may think, hey, what's going to happen to my home if something happens to me, my significant other, or both? You know, what's going to happen to my bank accounts, my retirement? Will that wealth be squandered? Will my beneficiaries or children, will my family members fight over what I've left behind if something happens to me? For others of us, it's about self-care. Your body, your choices honored. What happens if you become incapacitated? Who's going to speak on your behalf? Well, what do you want to happen to your body if something happens to you? Is it burial? Is it cremation? I know those are sometimes tough things to think about, but these are some of the issues that families are challenged and faced with if something happens to us. So these 4 topics in mind tonight: your choices, total assurance that there is a plan that can be put in place, peace of mind, not just for you, but peace of mind for those who are left behind, who may have to clean up your affairs if work is left undone. And finally, comfort. Comfort for those who we love and we care about and we cherish the most, our family, our friends, and maybe even some of the organizations that we'd like to see supported with the things that we've worked for. So, when was the last time you reviewed your existing estate plan? Now, we typically have 2 camps on these calls. We have one camp that says, hey, you know what? I already have my estate plan. I did my trust back in 1989, or I have a will. I have my affairs in order. I just want a few pointers tonight, Sedric. And then there's the other camp that says, well, I haven't even gotten started, and maybe I don't even know where to begin. So for those who already have that first camp, we already have a will, we already have a trust, we already have these things. I present to you, when was the last time you reviewed your estate plan? One of the number one ways that we see that estate plans fail is that they're just outdated. The laws have changed, your family dynamics have changed. Therefore, when something happens to you, the plan may not go as you drafted or had an attorney drafted for you 20, 25 years ago, or sometimes even 10 years ago. And for the others who may be saying, you don't have a plan, well, I have news for you tonight. If you don't have a plan, the state of California, unfortunately, they have a plan for you, and you may not particularly like what that plan is. So we'll talk about tonight what the state of California's plan is for those who do not already have a plan in place for themselves. So what is comprehensive planning? What is this comprehensive planning? Okay, so let me go ahead and get this screen positioned the right way. One moment here. So we talk about comprehensive planning. It's planning that takes all the phases of your life into consideration, not just what happens if you pass away or die. It's goal-oriented and solution-oriented, not just merely focused on documents. Your life and the things that you worked for is so much more complex and so much more precious than just a stack of legal documents. It's holistic and integrated. It takes into account your short-term, intermediate, and long-term goals. It also includes you having a trusted advisor, someone who your family can rely on if something happened to you, someone there to answer questions for you about this important phases of life, such as death, incapacity, legacy, wealth planning, and preservation. It's focused on ultimately your goals and your vision. So this holistic planning, so what does it encompass? Many of us on this call tonight, this video webinar tonight, we've done some financial and retirement planning. Many of us have said, okay, we started our retirement planning very early. Some of us maybe just getting started with their financial and retirement planning. But that's only one part of the Venn diagram. The other part is the estate planning. Why is that so? If you spend all your life building wealth, does it not also make sense to spend at least some time thinking about how you're going to preserve it, right? How are you now? Some of us may say, "Hey, I want to leave here broke, right? I want to make sure when I'm out of here, my last dime is spent." But the trick with that is we don't know when we're going to get out of here, right? So although we plan on dying broke, we might actually mess around and leave with some assets, right? We might actually mess around and have a nice retirement that someone's going to inherit, a home that someone's going to inherit, and other assets that someone's going to inherit. And this is where the estate planning comes into place. So let's talk about what is the typical experience like for someone who undertakes estate planning. Someone says, okay, I'm going to start estate planning. And there's two types. There's the planning for death and the planning for life. So what does planning for death look like? Here's your typical experience. It's a one-time transaction where you're just going to get a stack of documents. Then it may or may not avoid probate. It may or may not avoid estate taxes. It leaves your assets to your heirs outright and unprotected. There's no ongoing legal advice or legal guidance. And there's a potential to have the assets that you've worked for lost to the California State Department of Unclaimed Property. We see it happen every day. So then there's the other spectrum, which we call planning for life, right? Planning for life, because there is an afterlife, even if it doesn't account for you, it accounts for the people we leave behind. And it's not focused on a lot of times that way, what happens after we pass away. Life is going to carry on, right? So we call this planning for life, for the next generation, that circle of life, so to speak. So it's a new paradigm on planning that focuses on you making informed and empowered decisions. It'll save your family thousands of dollars. Your assets are not lost upon your death. It can protect your family from outsiders, creditors, predators, bankruptcies, and even divorces. Also, a lifetime of the right legal and financial choices, which will ultimately keep your family out of court and out of conflict. So I have a nice little pyramid here that I'd like to share that pretty much illustrates and outlines what the planning for life financial pyramid looks like. So if you look at the very bottom of the pyramid, it's the money management, right? Where there's asset allocation, risk management, there's taxes, making sure your cash flow is there. Then we have certain goals in life. Some of us have planned for retirement. Some of us have education goals, either for our children or for our grandchildren. What about healthcare? That can be costly and expensive as well. Home ownership, or perhaps there's a church or a charitable organization that you're passionate about. A level above that, we have to get organized. And we got to take control in order to make sure these things behind us or underneath here, lower in the pyramid, are taken care of. It means also ultimately taking care of our loved ones. And as we move higher in the period, it's going to give us more time, less worry, and then ultimately help us fulfill our life's purpose, which then defines what we leave behind as our legacy. So whether you're a business owner, a retired employee, it's pretty much the same pyramid for everyone in some shape or form. So I mentioned earlier that I would share if you didn't have a plan, the state of California has a plan for you. To die without a will is called intestacy in the state of California, right? And what we're doing is we're opening up ourselves to the government to step in and take control of our final affairs. Some of us on this webinar tonight have heard of the probate process. If we have not gone through it directly, we've heard of or know of someone that has gone through it, and it's never usually a pleasant experience. Okay, it's basically, in short, probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors. And whatever is left gets distributed to your heirs, your children, your grandchildren, your family members. So how does that look? So I put a nice illustration of a water faucet here because sometimes we all know what it's like to have a slow running faucet. And that's what the probate process looks like in the state of California. A lot of people live here, so a lot of people pass away here. So the court system is just not big enough to handle everyone who dies in the state on a daily basis. So this is how the process looks for the state. Whether you have a will or whether you don't, the probate process, this is how it looks. You're going to have to hire an attorney. So you can't represent yourself pro se. You can't represent yourself because one thing, you're not alive, right? At this point, you've already passed away. So someone in your family is going to have to hire an attorney to represent your estate. So that's at the top, hiring an attorney and the cost associated with that. Then the court's going to ask for different appraisal fees on the value of your different property. There's executor, the person who's overseeing the estate. This might be a friend, family one, or loved one. That executor is going to has expenses and fees that are going to have to be paid. What if the person who is the executor has to pay a bond, which is one thing that a lot of people don't know in the state of California, that you can actually waive the bond. But if you don't have a plan in place, the person who's going to step in as your executor may have to be bonded. Then there's court filing cost fees, and then there's creditors. Creditors, yes. Why creditors? Because the probate process is public. It's a public proceeding. If you don't believe that, anyone who's done a will in California, you can pay a small fee at the probate court and see everything that they left to their family right there in their will. And also, if we can see it, that means your creditors can see that as well. So all in all, it's a very slow process that can take anywhere from 6 to 24 months in the state of California. And that 6 to 24 months, these are pre-pandemic numbers. These are numbers these were the figures before the pandemic, before we had the coronavirus and the things that have impacted our legal system and made the court process even slower.
Excuse me, Attorney Sedric.
Yes, ma'am.
If a person okay, so I don't have a will, but I've made my, I've titled all of my assets, given them my beneficiary name. Do I still have to go through that process?
Here's the thing. We call that kind of a bootleg estate planning, right? I'm just going to name my beneficiaries. I'm going to name my wife. I'm going to put my kids on the designations. Here's the number one problem with that is that a lot of times your beneficiaries can unfortunately pass away with you. In a car accident, your spouse can be taken with you. You can have the kids in the car with you. And then we talk about kids. In the state of California, there's something called the Uniform Transfer to Minors Act, which means you cannot give a gift directly to someone who's under the age of 18. So for many of us who have kids and grandkids that we want to leave money to, it still has to go through the court system. So even if you have these beneficiary designations, there's still several scenarios where the court can still get involved. In the perfect scenario, it would bypass the court and go directly to that beneficiary. But that's in the perfect scenario. That's a great question, Bernice.
Thank you.
So many of us recognize the iconic faces on this particular slide. We all know who the great Aretha Franklin was, Marvin Gaye, Prince, most recently, Chadwick Boseman. The one thing that all of these iconic figures have in common is that they passed away without a will. And I can remember when I first learned of Aretha's passing, I grew up listening to Aretha and the struggle that her family went through. Also, Prince, his affair just ended. His estate just wrapped up a 6-year, I believe, is somewhere in the neighborhood of $160 million court battle. Now, all of us don't have $160 million like Prince, but we do have something. And we do have something that our family would perhaps fight over or be in court over. And so when I first opened up Legacy One Law Firm, one of the things that motivated me was I learned that, hey, there are so many people in the community, whether they're affluent or not, that don't have a will, affluent or not. 60%, in fact, of Americans in general do not have any type of estate plan in place. So this isn't a celebrity problem. This just isn't a Prince or Aretha Franklin issue. This is a nationwide thing that we have to tack on and we have to challenge as a community. So when we talk about one of the things about a will versus a trust, the will is the most, I guess, overly kind of romanticized traditional form of planning, right? If we all had it our way, what would be the perfect scenario? We've lived a long life right into our 90s, and then we passed away in peace in our home with our family surrounding us. And just before we took our last breath, we reached over and we signed our wills, right? But we're grown-ups and we know life does not work that way. This is why this planning is so important. And another thing that we don't think about with planning with a traditional will is that your beneficiaries can receive assets outright and unprotected. There's a reason why I'm showing kids on this slide, because some of us have kids, some of us on this call, we have grandkids, and we want to make sure they're protected, right? But they're under 18, or maybe they're just starting college. Are they really in a do they really have the wisdom or the maturity to handle a gift that you leave directly to them at 17 or 18? I don't know about you, but if my grandparents or parents left me $500,000 when I was 18, I'm going to buy a Porsche or Ferrari, right? Because I'm 18, I'm 17. We see this happen all the time. And with a traditional will, those assets are given to the kids or the young adults outright and unprotected. However, there are alternatives that we can put in place that can preserve that wealth for their education, for their health, or perhaps for their first marriage, or perhaps for their first business or first home that they want to purchase. And that type of planning does not happen inside of a traditional will. So this is how your kids could still be at risk, even if you have a will. I'm reminded of a story of one of my mentors. One of the reasons why she became an estate planning attorney is because when she was a little girl, she had a good friend who was around 8 years old, and his mother passed away suddenly of a blood clot while he was doing dishes. She was doing dishes in the kitchen. And the mother was smart, right? She cared about her son. So she was divorced, single mom. She had a life insurance policy that she had left in a will to her son. However, the other side of the story is that there is a deadbeat dad involved. There was hate to pick on the dads here. There's some great dads out there. But unfortunately, the dad got custody of the son, and within 3 or 4 years, that life insurance policy was squandered. It was left outright in the trust with no protection, in the will, without a trust and the will. And so there was no way that the mother could ensure that there was accountability to make sure that there was someone to kind of oversee things when she was left behind. She left that life insurance policy, and unfortunately, it was squandered. And she had a will and a life insurance policy.
Excuse me, another question that came up. So having a will transfers the assets over, but the person that's responsible for taking care of that child cannot use the money in that will or that insurance policy to take care of the child?
That's a great question. Great question. What happens is when you pass out the money directly in the will, see, here's what happens with minors. Minors, remember I mentioned earlier that you can't give gifts directly to minors because of the Uniform Transfer to Minors Act. So it has to go through the court system and through the guardianship system. So whoever is awarded custody of that child will most likely get assets to those funds as well, because that money is just given outright to the child. And if the spouse ends up with that money, or the surviving parent ends up with that money, without any accountability, they can do with that money as they please. And we've heard the horror stories about adults spending money and assets that were left for kids. Remember the whole situation that Gary Coleman went through when he was a kid. But that doesn't just happen to celebrity kids. That happens to everyday kids, that parents leave stuff behind kind of outright and unprotected. So a very good question. Yes, though, if you have the right type of planning in place, you can have someone overseeing the finances, putting those assets in the trust, which you control when the certain distributions are made to that child and when. Perhaps you want that child to have money for college or their first marriage or starting a business. Different types of planning, alternative plannings outside of the will, allow parents to have that kind of foresight for their kids. A very good question, Bernice. So planning your assets for inheritance can end, and these are some of the things that we can take a look at here when we talk about how can planning for your assets maybe increase the value for your beneficiaries, okay? So here's what an inheritance can do. There's non-retirement assets that can receive a step up in cost basis. So when we talk about what the right type of planning can do, we talk about non-retirement assets can receive a step up in cost basis. There's something called capital gains tax, right? That can hit your estate whenever you give gifts outright without the type of planning mechanism. And a lot of times, if you try to give, let's say, a house, a lot of times we hear folks say, I'm just going to give my house to my kids while I'm alive. Well, there are certain tax consequences that can come from that. With the right type of planning, you can get what's called a step up in cost basis, which avoid or minimize the tax liability that you or your kids have to endure from passing that gift or that asset to them. Also, there's the tax-free insurance benefits. Many of you have life insurance policies. We can discuss ways and strategies that you can actually maximize your growth through using a trust right now as well. So we can talk about the benefits of planning with your trust. We can talk about different strategies, how you can even use your life insurance proceeds to pay off the mortgage on your home before you pass it to your kids. So those are some of the strategies that we can, when we talk about tax planning, that we can focus on when we're planning and designing the proper estate plan. Because it's more than just planning for death. I say again, it's for planning for life, and it also has several tax advantages when done the right way. So we spend a lot of time talking about what happens if you were to pass away, but what happens if you survive the encounter? If you're in an accident and you're seriously injured, it's not just about death, like I mentioned before, it's about life. You survived the encounter, but now you're incapacitated. Who will speak on your behalf? Have you appointed someone through legal documentation to step in your shoes to make those critical healthcare decisions on your behalf? Secondly, what happens to your finances? If you're injured in an accident, if you become gravely ill and can't handle your financial affairs, how is your credit going to be protected? Who's going to pay the mortgage on your home? Who's going to make sure that your kids and grandkids have access to the resources while you're recovering? So some common planning, let's talk about some common planning techniques that don't work from what we've seen. Owning property jointly, designating a beneficiary, and just simply signing a will, right? These are very traditional. So owning property jointly, we think that sometimes that's estate planning, right? Well, remember I mentioned earlier, if you own property jointly with your kids or with your spouse, if they pass away with you, then there is really no plan for that asset. If husband and wife die suddenly, or a family dies together, or in short order, then what happens to that asset? So owning property jointly is not a plan. It's merely a way of owning the property, but it's not an estate plan. Also, we talked about earlier, designating a beneficiary. I call that the good old fashioned bootleg estate planning. I'm gonna name my mama, my cousin, my brother, my aunt. And then what happens is some of those are kids. Some of those people could pass away with you. Some of those people may not be responsible or even ready to inherit from you. And finally, we talked about some of the pitfalls of just simply signing a will, because signing a will signs you up for that probate process and leaves your kids still vulnerable if they're not ready to receive from you outright. So what is the solution? So you say, Sedric, we spent all this time talking about some of the pitfalls, but what is the solution here, right? What way can my family avoid court and avoid conflict? We like to call that solution a fully funded living trust with disability provisions. What does that include? Retitling of your investment accounts, making sure your bank accounts are owned or controlled by the trust, making sure the home that you live in today is properly titled in the name of the trust. All of your bond certificates, properties, the things that you work for, your beneficiary designations on your life insurance policy, they don't have just your spouse because your spouse could pass away. They don't just have your grandkids because they may be too young. But how about your trust? Your trust being the principal instrument that controls the distribution scheme and minimizing the overall cost associated and the time associated with going to court, and having that placed into the hands of someone that you trust to wrap up your family affairs. So what is this funding your trust? I'm here to share with you tonight that trust is not just a stack of documents. It's so much more than just a stack of documents. It's making sure that your assets are aligned with the trust. Your trust must be properly funded in order for it to work, or else it's just an expensive paperweight. Your non-retirement assets, such as your bank accounts, your investment accounts, your real estate, your life insurance. And then on the other side of the spectrum, you can fund it with your retirement assets, your 401k, your individual IRAs. Some of you have rollover IRAs from different employers. And some of us on the webinar tonight might be thinking, hey, Sedric, I don't have anything. I have very modest means. But most of us, even if our means are very modest, have some form of life insurance. And if you don't, perhaps we should have a discussion as to why or how you can get life insurance, right? Because for some of us, for less than the cost of a cable bill, we can have access to $400,000 or $500,000 in life insurance that would take care of our families pretty handsomely if something were to happen to us. And some of us on this call already have life insurance, but we're not sure if we have it set up the right way to properly take care of our family. So who else here wants to protect their inheritance completely, right? Do we like the idea of making sure our children don't lose their inheritance to the spouse or perhaps a potential lawsuit? What about estate taxes? This is the death tax I was talking about earlier. So fortunately here in the state of California, we do not have a death tax. I like to say they tax us enough while we're alive, right? So the state of California, they give us a break when we pass away, but the federal government does have an estate tax. So here's the good news. Well, the bad news is they do have an estate tax, but the good news is the exemption is at $23.1 million, meaning if you're married, husband and wife, you're exempt from federal estate taxes if your estate does not exceed $23 million. If you're single on this webinar tonight, it's currently $11.6 million. Now, that exemption is subject to change. And look, if the government does tax you, it's at a whopping 40% estate tax. So this is one of the reasons why my telephone rings. Now, we may be saying, hey, Sedric, you know what, $23 million, that's first world problems. But the reason why we bring this up is because this number is voted on by Congress and it changes periodically. Several of my colleagues remember when this number was at $2 million and at $5 million not too long ago. So estate tax strategies, there's several strategies. If this is important to you that we can discuss, gifting strategies, perhaps irrevocable trust that applies to you, life insurance policies, and so much more. So, but this is not just about money. It's not just about the things, but what about your values? What's important to you? Who will step in and raise your children or your grandchildren if something happens, right? So if you had to choose between, right, here's a quick question. If you had to choose between the people you love receiving your money or your values, insights, stories, and experiences, what would you choose? Many of us here tonight would choose the latter. They would choose our values are insights, stories, experiences, and estate planning can encompass so much of that. I sat and written down with parents specific instructions that they would want to leave behind with their kids. Some of my grandparents and parents get very creative, and they want to leave recordings as a part of their estate plan. There's different types of ways that you can pass down your values to the next generation, and we can have all of that memorialized for you. So the one size fits all planning. What's wrong with the cookie cutter, one size fits all? Let me just go into the internet, download a form, and plug in some information. I have a house, I have a dog, I have, 3 cars. This is where I want that to go. Because that's so cookie cutter, and it doesn't really take into account the unique dynamics of your family. It's much more than mere document preparation from an attorney or something that you pull off the internet. It also does not protect your assets from being lost to the state. As we mentioned before, it leaves your kids at the risk of being in the custody and care of strangers if you don't have the proper legal guardians to set up. And some of my people on the call tonight who are parents that have not set up nominated legal guardians for your parents. But what happens if something happens to you? Is the court going to decide who's the best person to take care of your kids? And finally, the traditional cookie cutter one size plan only addresses the financial assets of everything and doesn't really touch on what matters most to you. So how do we get started? You say, Sedric, we've heard enough. What is the process? Cut to the chase, why don't you? Well, look, every plan starts with, first of all, what we call a family wealth planning session. It's a strategy where you can help your family get more financially organized. You can make informed, empowered decisions. And so what we start off with doing is we don't want to see any of our clients' assets lost to the state of California. Right now, in the state of California, there's over $9.5 billion with a B in the California State Department of Unclaimed Property. The lion's share of that is there because when people pass away, they don't have any plans or their affairs in order. And so we have different planning packages. What does this family wealth planning session look like? It looks like an 1.5 to 2 hour meeting that we'll sit down together. We'll talk about what's important to you. We'll talk about your family values. We'll talk about what's important to you. We'll take a look at what happens under California law if something happens to you or your significant other or both. And so that way you can know with certainty that your family will receive expert guidance throughout the planning process. And so with that being said, tonight for those in attendance, we'd like to offer to you a special gift, okay? And so here's the special gift that we'd like to offer here, okay? So gift number one, we have a $750 gift certificate for all who are in attendance that would like to sign up for a family wealth planning session on this evening, okay? So if you sign up for a family wealth planning session, we're going to waive, for those who are on this call tonight, the $750 family wealth planning session. That's saving you money just for time to sit down and get all of these things together in an order. So that's gift number one. We'll waive the cost of your family wealth planning session to those who are on the webinar tonight. And gift number two, for those who are on the webinar tonight, we will give you a $250 discount toward any of our family planning packages that we have. Okay, so that's a total of $1,000 in potential savings to you and your family just for participating and taking action tonight, or maybe just booking a call to say, okay, Sedric, we want to learn more. How can we get started? How can we make sure that our family is taken care of? How can we keep our family out of court and out of conflict? So for those who are in attendance tonight, the $750 planning session fee, we're going to waive. For those of you who want to sign up tonight, they can take advantage of that $250 gift certificate that can be applied to any of our family wealth planning packages. So that's all I have. And the Bernice will be posting some information in the, for those of you who would like to book a call, a quick 20-minute call, just so I can get to know your individual situation one-on-one. I believe Bernice is going to post in the comments a link to where you can go right to my calendar and set up a time where you and your significant other can spend a few minutes with me so I can learn about your unique family situation and how it can help protect and preserve your legacy. And that's it. I thank you for your time. Bernice?
Thank you, Cedric. Now is the time where, as he has shared in the chat section, I have posted his calendar link. So if you'd like to schedule a time to meet with him, please click the link and it'll go directly to his calendar. Also in the chat section, I posted a notice that the poll section is open if you'd like to share your comments or thoughts about this event tonight. Now, with that said, if anyone has any questions, specific questions they'd like to ask or say, feel free to unmute yourself, and Mrs. Collins will be able to address your questions or concerns. This is your time to talk. Linda, you're quiet. Come on, let me hear you.
No, I just unmuted myself. So I have a question. So with respect to how you can use the life insurance to pay off the mortgage before the money goes to the beneficiary. So you were speaking about that. So are you saying that you can place a specific dollar amount from the life insurance proceeds into the trust and specify to pay it towards the mortgage or pay it off?
That's a great question, Linda. And so what you can actually do with the proper vehicle, such as a trust, is you can pretty much do whatever you want to do. You can have your entire life insurance proceeds go towards your mortgage. Let's say, for example, when you pass away, you have $400,000 left on your mortgage, but you have a $500,000 life insurance policy. We can set up provisions in your trust to have your trustee pay off the mortgage on your home before it goes to your kids. So the way that we're going to have your trust set up is that your life insurance proceeds are going to go to the trust first, and then we'll give specific instructions according to your wishes where you want those life insurance proceeds to go. And many of my clients say, hey, you know what? I don't want my kids to have a mortgage. I want them to take this house free and clear. So we'll use other assets, whether it's retirement or life insurance, to pay off that mortgage. Alternatively, if you don't want to do that, you can have your kids take your property with the mortgage. So there's a couple different strategies, Linda, that you and I could discuss if that's what you intend to do.
So then the life insurance does not have to be placed inside of the trust.
Well, the life insurance isn't actually placed inside of the trust to begin with. Okay. The trust is named as the beneficiary of the life insurance policy.
Okay.
Exactly. So that way your trustee, whoever you appointed, has access now to those funds instead of a person or an individual. The person who you trust to manage your affairs gets the check to distribute that check according to your wishes. And if your wish is it for it to pay off the house, then it pays off the house. If your wish is it to pay for college, it'll pay for college. You get to decide how that asset is used through your trust.
Okay. So is that part of funding the trust? I keep asking this question.
Yes, that is part of a great question, Linda. Yes, ma'am. That is part of funding the trust. Absolutely.
I need to talk. I have so much to do. I thought I was done, but I'm not done. So you actually review. I have a current trust. It probably needs a review. And it probably needs tweaking, so to speak.
Absolutely.
I'm thinking that's what needs to happen. I need to have it tweaked because it looks like things need to be specified. Mine is probably cookie cutter. It covers everything. I had it reviewed by a friend who's a probate attorney and did trust and things like that previously. But also, she just said it was fine. But there are other trusts that I've seen, and speaking to Bernice, things are very, very, very well laid out down to the cell phones. So that's it.
Absolutely. Absolutely. So I'd be more than happy to speak with you, Linda, about your individual situation. If you'd like to use that link to schedule a free call, and we can discuss your individual situation, and I'll be happy to discuss a review to make sure that your trust, it accurately reflects your wishes.
Yeah, because I think I need to make certain that it's funded properly, and I don't believe I have it set up funded properly. But anyway, I'll make a note so we can talk. Okay.
Absolutely. More than happy to speak with you about that, Linda. Thank you so much for participating.
Okay. Sure. Thank you.
Donna, you had a question?
Yes, I have a question. What's the difference between a fully funded living trust and irrevocable trust?
Well, an irrevocable trust, that's a really great question, Nona. An irrevocable trust, basically, you cannot take that trust back. It is irrevocable. And I really, most of my clients, 99% of my clients do not plan with an irrevocable trust because it doesn't allow the flexibility that a revocable trust has. A revocable trust means once you create the trust, you at a later time can revoke that trust, you can amend it, you can change it. But once that irrevocable trust, it's more so set in stone while you're alive. And so it has its own tax ID number. There can be tax implications involved. It's a much more sophisticated instrument that's not really the cornerstone of estate planning, in the same way that a revocable trust is. So 99% of the time when I'm doing a plan for a client, it will be a revocable trust versus the irrevocable trust, just because of the permanence that's involved. So if you believe that you would need an irrevocable trust, we'd have to have a consultation one-on-one to discuss your individual unique needs as to whether or not that makes sense for you.
We have an irrevocable.
Go ahead, Nona.
So what's the point of having an irrevocable trust fund?
Well, the thing is, an irrevocable trust, some people want certain tax provisions to be in place. Some people want to make certain gifts to reduce the size of their estate. So it's a very case-by-case basis. Most of my estate planning clients, if not all, plan with a revocable trust. If you have special needs that you have to have considered, do you have an irrevocable trust, if you don't mind me asking?
We have to go check this. It's been a while.
You were saying, yes, you do? I'm sorry, it cut out for a minute.
I'm not sure. I have to go back and check.
But you have some type of existing trust, but you're not sure
Yes.
whether it's revocable.
Yes.
It certainly, I mean, so if you're uncertain, if you want to schedule a time to talk, I'll be more than happy off this call to maybe help you to determine, because there's certain clauses that right up front state whether or not it's revocable or irrevocable trust.
Okay. Thank you.
So, yeah, I'll be more than happy to discuss that with you, Nona. Absolutely.
Yes. Thank you.
So I have another question. I'm sorry.
Go ahead.
Can I get
Go
ahead
ahead,
of one?
Linda.
So I have a friend who recently passed away, and she had a trust, and the executor of the trust has to get an EIN number. What is the purpose of that?
Okay, very good question. That moves into the realm of estate administration. When you're
Okay.
alive, your revocable trust will use your social security number for the time that you're alive. But when you
Okay.
pass away now, you're no longer here. Your trust now needs its own EIN number for tax purposes.
Okay.
Because it's basically the federal government wants to know. Remember, I talked about that death tax?
Yes.
That's where this all kind of comes into place now.
Oh,
Let's say if you passed away and your estate was now worth, just you as I don't know if you're a single, let's say you're a single and the exemption is $11 million and you have a $12 million estate. Now
okay.
you owe the government some money in taxes. So they're going to want to be able to collect that tax. And so there's a final tax return if you have a trust that can be filed, where the IRS wants to see what's the total size of your assets in your trust. It's the same thing as an individual has to go through when they pass away. So even if you don't have a trust, right, the size of your assets they're going to be attached to your social security number. But if you have a trust, everything's in your trust now. So your trust needs its own kind of social security number, so to speak. So that's what the EIN is for.
This is getting to be really deep. I'm learning more and more and more because it's a lot of information, but it's a lot of good information because most folks don't know this, and I didn't know that either. I didn't know how that actually worked. So now I understand it a little bit better each time I hear this webinar. And that's what I was trying to understand. Why did he have to get an EIN number from the IRS? But and I guess it's to allocate, and as you're saying, to collect taxes. I don't want to pay taxes. I never want to pay taxes. So
none of us do, Linda. And the good thing is the exemption. I don't know what your financial situation is. if you're blessed enough to have a $20 million estate or what have you. But still, even those people don't want to pay taxes, right?
Yeah.
And so there are different tax strategies that can be done to mitigate the size of your overall taxable estate. And that involves some estate planning. But for most of us, right now, we're in no danger with the current exemption, but it's going to lower. And if they do lower it to what we're thinking, it's going to be lowered to, it may have implications on more people, many more Americans.
Yeah. I'm just thinking now that everything I have needs to go in my trust, because everything is not in my trust. As I'm thinking about it, everything is not there. There are beneficiary designated things that 457 plans and all sorts of things that are not. And I think we talked about this before. I need to name as beneficiaries or as contingent beneficiaries. Okay, I have some work to do once I finish this project.
Okay.
Probably before then.
Let's happy to have a conversation with you, Linda.
Okay, great. I'll schedule some time.
Absolutely.
Thank you.
You're quite welcome.
Cedric, for those that are on the call, can you go back over, okay, you said that the benefit that if someone were to call you now or go through the wealth planning session, what is it that they get out of it? Can you share a round of the cost or what you referenced before the last screen?
Okay, yes. In terms of the gift?
Yes.
So as an incentive and to help people take their first step for attending this call, there's going to be two things that Legacy One's going to do. If you sign up, if you first of all do the consultation, the 15-20-minute consultation, that's the link that Bernice is going to share. And we're also going to share this link in an email. That gets you on the calendar for a 20-minute consultation. If you decide that you want to actually schedule a longer meeting where we're going to actually take a look at things closer, we'll waive that $750 cost that it would normally cost to have that planning session with me. Okay, so that's as a gift. The second gift is for those who are on the call tonight and they book a call to tonight, we'll waive or I've even done this for people if they've done it the next day, if they got on the calendar. If you needed a night to think about it and you signed up tomorrow, I'll still let you use your $250 gift certificate for attending this webinar. I'm not going to be that much of a stickler. So if you called us tomorrow or signed up tomorrow for a date in the future, I would still honor that $250 webinar certificate for attending the webinar. So it's $1,000 total in savings for your planning.
Thank you.
You're quite welcome, Bernice.
Where's your office located?
In Brentwood, West LA.
All right. Are the estate planning, for the estate planning, is it usually a one-time, two-time appointment or?
Well, typically for the estate, typically it starts off with that family wealth planning session.
Okay.
So that's where we're looking at the law. We're looking at your unique family situation, and we start designing the plan from there. Okay. It takes 3 to 4 weeks to actually finalize everything because we can't knock out everything in one call. But we can at least lay the foundation for what's important to you. And we'll talk about some of your hopes, fears, aspirations, some of your goals. And we'll really dig deep during that meeting. And then it all culminates with a signing ceremony to where you'll actually sign your estate documents. And that can be done virtually or it can be done in person.
Okay. All right. Perfect. Thank you.
Good question. So we're definitely aware of the times. So we try that most of the planning can be done virtually, like a video. If you're able to access this video call, we'll have a one-on-one call for our family wealth planning session. That'll look like this, but it'll be with you and addressing your own family's individual and specific situation. We know that this is kind of general for everyone here, but when we get on that one-on-one, it'll be about you and your family, what's important to your family.
Okay. Sounds good.
Absolutely.
I have a quick question. My name is Linda Harriman, which you could probably see. But do you provide assistance with deciding how to equitably distribute your assets with children if you don't have children together? My husband and me both have children, and that was a roadblock for us in our estate planning.
That's a great question, Linda. So planning for blended families. Absolutely. In fact, I wrote a blog article on this. So if you visit my website, we have an education forum for clients. We actually have recently wrote an article on this, talking about planning specifically for blended families. Absolutely, because when people get remarried, people have children from other relationships and what have you, and it's very important. In fact, sometimes it's even more important to have a plan, because children could be inadvertently disinherited, or they can be intentionally disinherited if we don't have the right plan in place. So we can certainly talk about your situation. We have several clients that have blended families. They've been married a couple of times. They have kids. Some of their kids are adults. Some are still minors. Some of my families, they have separate kids and kids together, right? So we can certainly discuss what's important, the values between you and your spouse, and we can certainly come up with an equitable distribution scheme to make sure all the kids are taken care of from both parents. Absolutely.
That's great. Thank you.
You're quite welcome.
Are there any other questions or additional information that you'd like to address? There's a question in the chat, Sedric. What is the average cost of a trust? Could you share that?
Yes, a very good question. So we have estate planning packages at Legacy One Law Firm. We don't believe in billing clients by the hour. That's really a turnoff. I don't know if anyone on this call has ever hired a traditional lawyer. Lawyers traditionally bill every hour in that 6-minute increment. So if they're reading your email, you're getting the bill. You're on the phone, you're getting the bill. We take all the mystery out of that. We have planning packages. Our planning packages on the low end start at a few $1,000s. They go up as high as $6,500. Okay, and you can pick anywhere in between depending upon your unique family situation. So when we have that family wealth planning session, we'll go over our planning packages, and our clients choose what package makes the most sense to them. And based upon your unique family needs, that's what the price is going to be. So before you hire us, you'll know exactly what the price is, and that's it. There are no mysteries. There are no surprises. That's what it'll cost to get your estate plan established. So the short of that, $3,000 on the low end, up to $6,500. But don't get intimidated when you hear the $6,500. I do have some clients that have more money than time, and they have very complex, sophisticated estates. So we'll find the pricing point that's right for you. And we don't lose clients over pricing, because we find a way to make the money work when our clients want to get this handled. Absolutely.
Thank you.
You're quite welcome.
Are there any other questions or anything else someone would like to address? Well, if there isn't, I want to thank everyone for joining us for this webinar. As I said previously, Sedric and I are looking at doing this on a monthly basis. So you may get some information on our next one. And at that time, feel free to share that with and invite others to come and learn about legacy planning. And with that, if nothing else is said, we want to thank you and thank you for your time.
Thank you, everyone, for coming out. We appreciate the opportunity to share this information with you.
Oh, Linda, you got one more?
That's a clap. Thank you for the clap. She's clapping.
Oh, the hand clap.
Linda. She's a clap. Thank you.
Thank you.
Good info. Thank you.
You're welcome.